All right, the next case set for argument then is Joyce Scott, executor of the estate of James Helms versus Akron Housing Appeals Board. It's case numbers 29163, 29274. Both parties are represented by counsel, so we will hear 15-minute arguments from each of you. Of course, you may reserve up to 5 minutes as the appellant. For rebuttal, if you choose to do so, let me know. And we've read the briefs and are prepared to proceed if you are Attorney Benton.
Thank you very much. I would reserve 5 minutes.
All right, thank you.
And if it please the court, I am Alan Medwick. I am here representing the appellant Joyce Scott as executrix in this matter. This is an appeal from the dismissal of an administrative appeal at the trial level. And the second appeal number is the appeal from the motion for relief from that judgment, which was denied. And the issues here regarding the initial appeal, it's undisputed that the appellate brief was not filed within 30 days of the record being transmitted, and 3 days after that deadline was missed, the trial court dismissed the administrative appeal. The argument of the appellant is that that is an abuse of discretion. Ms. Scott had been involved in the case throughout, had agreed to an extension of time to try to reach a resolution on this matter for the transmission of the record. It was not in a flagrant disregard of the law. This was a brief time after the deadline was passed. It's not disputed that the deadline did pass. But in very similar facts, there's a case out of the 8th District, AG&G Company, 47 Ohio Ave 3rd, 117, where a dismissal where the brief was filed 6 days after the passing of the deadline, was considered an abuse of discretion. This is a procedural and factual. It's undisputed that it was beyond the deadline. It's a factual error, a procedural error, and was not done with disregard for the court or in clear contempt. This was something that could have been remedied quickly and did not create an abuse to the court or contempt. Regarding
the local rule in Collier County specifically provides that failure.
I think it is practically identical to the law.
Well, I know ours specifically provides that the
Yes.
court can dismiss the case.
And the language in the local rule in Cuyahoga County
Same.
does as well. I believe the language is substantially identical. Then Ms. Scott took an appeal from that dismissal, asked that this matter be remanded so that she could pursue 60B relief, filed that, and that was subsequently denied as well, based on not on any the appeal. The 60B motion is timely. There is no consideration for the basis for excusable neglect was what was raised, and ultimately was dismissed for the failure to raise meritorious defense, claiming that the facts asserted were not sufficient to create a meritorious defense. Those being that at the administrative appeal there were hearsay witnesses permitted to testify that were improperly heard, and that the resolution of tearing down the property was in excess of what was necessary. It was not the least restrictive, the least damaging outcome.
Was your argument that there was hearsay?
At the administrative hearing.
Hearsay is allowed.
And the question would have been that would have been beyond what is permissible, and as stated in the city's brief, that if there are proper indicia of reliability, and the argument is that there should have, with those issues having been raised, and they were factually significant and clear enough that at a minimum an evidentiary hearing regarding what those factual issues were should have been held before the dismissal of the case. That was not done, and that is where there's an abuse of discretion in the 60B argument on the other side is that that was not the case. Beyond that, as I said, back to the original dismissal, Ms. Scott had been involved in the case. The parties had agreed to an extension of time to try to work things out. She was not in utter disregard for the court. Those are the essence of my arguments. I would withhold the balance of my time. And,
Well, you'll have a full 5 minutes for your rebuttal.
thank you.
15 minutes.
Thank you, Your Honors. Good morning. I am Brian Bremer on behalf of the City of Akron in this case. I believe that the matter before you is fairly straightforward. The issue is really, as the appellant has laid out, whether or not the trial court uses discretion when it dismissed Ms. Scott's appeal when no brief was filed within 30 days of the record being transmitted. And really the issue is whether or not the deadlines that are set forth in the local rule are enforceable deadlines or not. There's no dispute that the deadline was missed. There's no dispute that no brief was filed before the dismissal went out a few days later. And under those circumstances, is that abuse of discretion where you followed the local rule that gave notice to the appellant about when they needed to file the brief? And I would also add that it's important to keep in mind in this case, this isn't even a situation where a brief came, it's not even just a normal administrative appeal where an issue is appealed, the brief goes out to the administrative body files the record, and then you have 30 days to file the transcript. What actually happened here was the court, there was extensive time granted for the filing of the record, as appellant pointed out, to try to resolve the issue if we could. And then the court put on an order saying when the record had to be filed in this case. And that was, when that order went out, it actually specifically said that the record had to be filed on or before June 29th, which essentially gave the appellant notice 60 days ahead of time when the last possible deadline for their brief would be. And so for 60 days they knew when this deadline was, and they did not file their brief within that time period. The court was aware of that, and the court could have weighed that when they're making the decision about whether it was appropriate under these circumstances to dismiss the case. And it's also important to keep in mind that there is a remedy here available to that they can pursue, which, and I don't mean this appeal necessarily, I mean the 60B, because the 60B permits them to say, was this actually, did this actually matter? And was this actually something that should have been, if we actually had the briefing, would this have made a difference? And that's, in some ways, a more efficient use of court resources to have the 60B be the method to reopen these appeals. Because under these circumstances, the appellant did pursue the 60B. It was denied, but it was denied because they failed to set forth a meritorious defense with specificity. The court reviewed the motion, and the court found that there was not a meritorious defense that was actually alleged. And if you look at the way the pleadings went forward, it's all generalities. The idea of hearsay is raised, but they don't point, the record was filed in this case. The record was before the court. And unlike a normal, more usual lawsuit, the court's confined to that record. So if you're going to raise issues saying, I have a meritorious defense, you need to be able to point to the record and say, it's on this page that this is hearsay. It's on this page that we raised the issue about other alternative remedies that they did not consider for us. But that never happened. And under the facts of this case, they really had the opportunity, and they were required to argue specifically based on the record before the court what the defenses could be. They didn't need to prove them. They did not need to they did not need to lay out their entire appellate brief, but they needed to say it with specificity. And in this case, it's not just a case of saying, well, I think the evidence will show this. The evidence was before the court, and they should have pointed to that issue so the court could have actually seen, was the statement they're complaining about hearsay? Was it actually something that, could even be considered by the board? And if that was the case, then that would they could have possibly risen to the level of being a meritorious defense that would have justified reopening the appeal. But the court that did not happen here, and so the court properly determined they had failed to meet the one prong of 60B. And the other point I will make, though, is in their brief they suggest that the court did not dispute that there was excusable neglect. The court, I feel it's a little bit unusual phrasing because the court is to determine whether there's excusable neglect or not. The dispute would be from our side. We did dispute the excusable neglect, and the court never reached that issue because once the court decided the first prong of the 60B, the court did not hit the rest of the points under the 60B test. So even if this court were to determine that the 60B, the first prong was met, it should still go back to the court to determine in the first instance whether excusable neglect occurred in this case.
Haven't a number of courts held that 60B motion is not appropriate for an administrative case? For an administrative appeal, I should say.
I'm actually unaware of that.
Okay. And I might be wrong on it as well.
I'm unaware of that
Okay.
case law directly.
And I'm not saying that I know. It popped into my head, so I thought I'd ask you. Go ahead.
So again, I understand the case law that is out there. I think it's important to look at each case on its facts. I think that it's important to keep in mind that the appellant knew in this case when the brief was due. The deadline for this brief was known for about 60 days before this, it was known 60 days in advance. And then the court did not dismiss it the next day. The court gave a few extra days. And that's on top of the fact that it was that because of when the transcript was filed and when the deadline would have normally occurred was a Saturday, they already had additional days. It wasn't just 30 days from the day that it was filed, they got an extra 2 days. And so when the court actually made this ruling, it was about the 35th or 36th day after the record had been filed. So it was a little bit more, there was even more time that passed from when the brief would have normally been due 30 days afterwards. Obviously by rule, they would get till Monday, but it still factors in, I think, into the decision-making process about, you had 2 extra days already and you didn't file the brief, you didn't ask for an extension, and then on top of that, you don't do anything the next day, the day after that, and then on the third day, the court dismissed the case. And under these circumstances, I do not believe that that is an abuse of discretion by this court. It's something, and the rule has to mean something. And if the idea is that it's improper to dismiss after 30 days, is there a point in time when it would be proper? Is it 30 days plus 10 days, 30 days plus another 30? At some point, the deadline has to pass, and in this case, the deadline is set forth in the local rule, and the court should not be reversed for enforcing that rule that they had notice of.
Is the Cuyahoga County rule similar?
I believe that it is. I will say the Cuyahoga County case, the case is what it is. It says that they found that there was an abuse of discretion. I would argue that it was improperly decided. I think that it's giving too much leeway to individuals who bring, there should be, the rule should be enforced, and it's not exactly an onerous rule that requires you to at least ask for an extension prior to the deadline passing. If they filed a motion for an extension of time at any point during those 30 days after the record was filed, this would be a completely different case. But they didn't do it. They completely disregarded what that rule said under the circumstances here. And I would argue that that is not an improper thing for the court to consider when making the decision that it did. Notwithstanding what the 8th District has said, again, that case is out there. think that it is a little bit unfair to trial courts and common police courts. And I think it's also unfair to entities that are defending against these cases. The administrative process is supposed to be swift, it's supposed to be, get to justice, but at the same time not be dragged out in the same way a court proceeding is. And if someone can appeal and then just drag out a case longer and longer and longer, it defeats a lot of the purposes of having administrative proceedings like this. And it's also, for example, in this case, if you look at the record that's actually before the court, orders have been on this house for, I believe, a decade before this HAB hearing actually ordered the house be demolished. So it's actually, again, this is not like this process went, this is the tail end of a very long process, and somehow we're still dragging it out longer, and that could have been something the court considered as well. Albeit it is not actually in the court's decision. The court's decision is very short and to the point. It just says that they failed to follow the brief within the 30 days provided by the rule. If there are no further questions, I will respectfully request the court affirm the decision of the Suffolk County Court of Common Pleas.
All right, no questions, so thank you for your argument. Counsel, you'll have 5 minutes for rebuttal.
Thank you. I would agree with the city regarding the fact that each of these cases in this instance should be considered on their individual facts. And what I would point to in the facts of this case is that this is a party who was actively involved in this case, who was taking part of it, agreed to the extension of the record. I know that we are interpreting that extension in very different ways, that the city wants to point to that as a notice of when that 30-day deadline would be. I would indicate that this is also indicative of my clients not abandoning her rights under this case, not abandoning her intent to pursue this case. This is not a case, as often happens in administrative appeals, where people will pro se file an administrative appeal and then simply ignore the balance of any action beyond that. That does happen, and that is the instance where that 30-day rule has some applicability. It's more in line with a default judgment. And I'm not saying that it's not applicable here, that my client would not be on that deadline. I'm saying that the outcome based on the facts of this case, and similar to the Cuyahoga County case, warrant a different consideration. And that is also indicative of my client's continued participation here. This is not a case where she's taken no action. And that is what I would point to, is that this is the order to extend the record was by agreement of the parties was involved in the action. We were all here in this case, and so we're looking at this as a case where the party was involved and a deadline was missed, as opposed to where no action had been taken and the court was simply being ignored. And that's why we're here today. Obviously, the appropriate remedies are not distinct of the ability to appeal to this court or to seek 60B motion. Obviously, with the timelines restricting when a notice of appeal must be filed, obviously this case needed to be brought in order to preserve that calibrate. As was proper, we filed the notice of appeal here. We remanded to address the 60B motion, and that's why we're up here on both cases at this point. You know, the actions taken here and in the trial court on the 60B level are different burdens. They're different facts being pursued. Here, we are on appeal, in particular regarding what is an error at the trial court level, an abuse of discretion regarding whether this case should have been dismissed or some other remedy should have been sought or provided. The 60B motion is a consideration of the meritorious defenses and whether there was, it's a different set of circumstances and facts considered, and that's why we're here on both cases.
Counsel?
Yes,
I'm
sure.
going to ask you the same question as
Sure.
Judge Tito's who asked the city. There does seem to be a line of cases that talks about that 60B is not applicable to administrative appeals because it's a special statutory procedure. What's
Yes.
your reply to that?
And again, that's not a line of cases that I have investigated, and I would argue that we're both a bit ignorant in that
Oh, that's okay.
regard. I apologize if that is the case. Obviously, that would I think probably support the argument that the only remedy is here, and in this court, and regarding seeking the abuse of discretion for this dismissal. And if that is the case, then that would, I believe, bolster the argument of this being an extraordinarily harsh outcome for something 3 days after when the client, the parties on both sides have been involved actively. With that, if there are no other questions, I would cede the balance of my time.
All right, thank you both for your arguments this morning. The court will take the matter under advisement, issue a decision in due course. Of course, clerk of courts will mail you each copy of the decision on the day it's released. And you may also find the opinions on Supreme Court of Ohio's website where they are posted. Thank you both.
Thank you.